Special lecture on the Missouri Constitution, Part 2. Okay, so now we're on to the Constitution of 1945, the last Missouri Constitution, the one we are currently on, or the one that the state of Missouri is currently on. The last Missouri Constitution was drafted in 1945, right at the close of World War II. During World War II, voters called a constitutional convention to revise and update the Missouri Constitution. By this time, by the mid-1940s, the 1875 Constitution had become severely antiquated, with frequent and numerous amendments, really too many amendments, many of them contradictory to one another. The Constitution also was outdated. It reflected a largely rural and agrarian society that Missouri no longer resembled, and as a result, rural areas were overrepresented in the state government. The state's large urban population, which grew even faster during the war, was not adequately represented. The Constitution of 1945 created the form of government and distributed political power, like all constitutions do. Like the U.S. Constitution, the new Missouri Constitution established a representative democracy, or another way of putting that would be a Republican form of government. In other words, the citizens are guaranteed the right to elect their own representatives who make decisions on their behalf. As with the U.S. Constitution, the ultimate authority of the government in Missouri rested in the hands of the people of Missouri. As in the U.S. Constitution, the civil rights of Missourians are protected by a Bill of Rights. Article 1 of the Missouri Constitution contains the Bill of Rights for the state. The Missouri Bill of Rights is much more detailed and covers many more issues than does the Bill of Rights in the U.S. Constitution. Article 1 covers a variety of issues related to civil liberties, including the right to due process of law, habeas corpus, ex post facto laws, the powers and compositions of grand juries, eminent domain, and crime victim rights that are not specifically mentioned in the Federal Bill of Rights. So let's talk about some of these things that the Missouri Bill of Rights has that the U.S. Bill of Rights does not. First off, due process. This is the guarantee that no one can be deprived of life, liberty, or property without some type of legal proceeding, such as a trial. It's the equivalent to this provision in the U.S. Constitution would be found in the 14th Amendment, which is not a part of the Bill of Rights. Then there's habeas corpus. This is the guarantee that no citizen can be incarcerated or held against their will without being brought into a courtroom and formally notified of the charges against them. Now, habeas corpus is in the U.S. Constitution, but it's in Article 1, Section 9, not in the Bill of Rights. Then there are ex post facto laws. Article 1, Section 13 declares that so-called ex post facto laws, or laws criminalizing behavior after the fact, are unconstitutional in Missouri. In practice, what this means is that neither the state legislature nor local governments can retroactively criminalize a certain type of behavior. So, for example, Branson can't pass an anti-littering law that punishes you for littering 5 years ago. Grand juries. Article 1, Section 16 contains rules for grand juries. It says that a grand jury is to be convened by the order of a judge and consist of 12 citizens. 9 of the 12 members must concur in order to hand down an indictment against a person. Then there's eminent domain. Article 1, Section 26 deals with eminent domain, or the right of the state to take property for public use, to take private property for public use, provided that the state give just compensation for the property confiscated. In addition to these provisions, the Missouri Bill of Rights also covers a number of civil liberties issues that are addressed in the Federal Bill of Rights. For example, the right to keep and bear arms. Like the Second Amendment in the U.S. Bill of Rights, Section 23 of the Missouri Bill of Rights provides for the right to keep and bear arms. Unlike the National Bill of Rights, however, which ties the right to keep and bear arms to the maintenance of a well-regulated militia, the Missouri Bill of Rights gives this right to any citizen, quote, in defense of his home, person, or property. So in other words, the rationale for the right to keep and bear arms in the Missouri Bill of Rights is different from that stipulated in the Federal Bill of Rights. Then there's the right to religious freedom or religious liberty. Section 5 of the Missouri Bill of Rights protects religious freedom. In Missouri, it says that all Missourians have the right to worship according to the dictates of their own consciences, and that civil liberties, i.e. the right to vote, hold office, etc., can't be limited because of religion. So in other words, the state of Missouri forbids either the state government or the local governments to deprive you of your civil liberties because you go to the wrong church or synagogue or mosque or whatever. Then there's freedom of speech. Section 8 of the Missouri Bill of Rights declares that, quote, no law shall be passed impairing the freedom of speech. Every person shall be free to say, write, or publish, or otherwise communicate whatever he will on any subject, end quote. Like the U.S. Constitution, the Missouri Constitution provides for a separation of powers between the executive, legislative, and judicial branches of government, with power more or less equally divided between them, so that no one branch of government can run roughshod over the others or dominate the entire state government. Article 2, for example, states that all legislation must be passed by both houses of the General Assembly, and it gives the governor the veto power over state legislation. And it grants the judiciary the power of judicial review to determine if acts of the legislature or acts of the governor are in keeping with the state constitution. So there is a definite checks and balances system built into the Missouri Constitution. Article 3 covers the legislative branch of Missouri's government. Like the U.S. Constitution, Missouri has a bicameral legislature, which is known as the General Assembly. The legislative branch of state government is responsible for writing, debating, and passing all new state laws. Article 3, Section 2 sets the number of state representatives in the Missouri House of Representatives at 163, and it defines the limits of House districts. Members of the Missouri House of Representatives must be at least 24 years of age, a qualified voter for 2 years, and a resident of the district they represent for at least 1 year. They serve for terms of 2 years at a time. And current term limits limit them to a total of 4 terms, or 8 years in the House. Section 5 of Article 3 sets the number of senatorial districts at 34, and Section 6 establishes the qualifications for state senators, who must be 30 years of age, a qualified voter for at least 3 years, and a resident of the district they represent for 1 year. They serve for 4-year terms, and they can be elected to a total of 2 terms. Article 3 also includes sections on legislative proceedings, limitations on legislative power, and many other issues. The General Assembly is required to meet for 4.5 months each year, beginning in January. Senators and representatives work on bills in bipartisan legislative committees with a majority vote to decide the fates of a bill during executive session. The Assembly is required to hold public hearings and give citizens an opportunity to speak out on any given bill. Article 4 defines the powers and responsibilities of the executive branch of state government, as well as the qualifications for those who hold the office of those who hold office within the executive branch. The basic responsibility of the executive branch is to execute or administer the laws passed by the state legislature. That's its fundamental responsibility. This branch is headed by the governor of Missouri, who must be at least 30 years of age, a citizen of the United States for at least 15 years, and a resident of Missouri for 10 years. The duties of governor are to, quote, take care that the laws shall be distributed, and the laws are, sorry, let me back up and restate that. The duties of the governor are to, quote, take care that the laws are distributed and faithfully executed, and to be a conservator of the peace throughout the state. So in other words, the governor has the responsibility for maintaining peace and order in Missouri and making sure that the laws are enforced. Additionally, the governor has the power to appoint and fill vacancies in non-elected offices of the state government and commission all officers who are not otherwise provided for by law, and he can remove those officials if need be. The Constitution also delegates to the governor the role of commander-in-chief of the state militia, and he can call out the militia to protect the state and to enforce its laws. Now today, the term militia generally means the National Guard. So the governor is essentially the commander-in-chief of the Missouri National Guard. The governor's right-hand man in this capacity is the adjutant general. He's kind of second in command to the governor, and it's his responsibility, the adjutant general's responsibility, to oversee the operations of the National Guard on a day-to-day basis. Governor also has the power to grant reprieves, commutations, and pardons to those convicted of a crime. The governor oversees state expenditures and can call special sessions of the General Assembly. The term of office for the governor, according to Article 4, Section 17, is 4 years, and gubernatorial elections are to be held at the same time and date as presidential elections. Finally, no person can be elected governor of Missouri more than twice, so you're limited to 8 years as governor. Aside from the governor, the major offices of the executive department include the Secretary of State, the Attorney General, the State Treasurer, and Auditor. And these people are all individually and independently elected directly by the people. This ensures that the governor does not have the ability to control these officials as he would if they were his appointees. In fact, many times these officials are from another political party entirely. The executive branch also includes many smaller departments and enforcement boards such as the Departments of Revenue, Highways and Transportation, Department of Social Services, Department of Conservation, and Department of Agriculture, which are not cabinet level departments. Now, I would make one point here, and that is the fact that the governor does not appoint members of his own cabinet, the Secretary of State, Attorney General, State Treasurer, etc., is a significant difference between the U.S. Constitution and the Missouri Constitution. With the U.S. Constitution, the President pretty much appoints all of the members of his own cabinet. So he has a great deal more direct authority over the executive branch within the federal government than does the governor of Missouri within Missouri's government. Article 5 deals with the judicial branch of Missouri's government. The judicial branch of the state of Missouri basically has three levels to it. It has a Supreme Court, a Court of Appeals, and then at the local level it has circuit courts, which handle most of the casework, most of the civil and criminal cases that come before the state judiciary. The Supreme Court consists of 7 judges meeting in Jefferson City, Missouri. The judges on the state Supreme Court and the Court of Appeals serve for terms of 12 years. Circuit Court judges serve for terms of 6 years, and Associate Circuit Court judges for 4-year terms. Article 6 deals with the powers and responsibilities of local government. It recognizes counties as the basic legal subdivisions of the state of Missouri. Missouri has 114 counties. Article 6, Section 8 provides for the classification of counties and differentiates their powers based upon their size as well as the assessed valuation of their taxable property. Missouri was the first state to permit cities to frame and adopt their own charters. The power of home rule gives counties with populations above 85,000 people and cities with populations above 5,000 a certain degree of independence and flexibility in managing their own affairs. And of course, counties in Missouri, as with counties throughout the United States generally, have certain rights in common with the state government, certain powers in common with the state government. They have the right to tax their citizens, typically through local sales taxes, to issue bonds, and to draft local legislation or ordinances which are binding and enforceable within the boundaries of each county, so long as those ordinances do not conflict with state laws passed by the General Assembly. In addition to the aforementioned 6 articles, there are several other articles in the Missouri Constitution which you need to at least be somewhat familiar with. For example, Article 7 discusses the public officers of the state government of Missouri, what their duties and qualifications are to be, how they can be impeached or removed from office, and what compensation they are supposed to receive. Article 8, Section 1 states that general elections are to be held on the Tuesday following the first Monday in November of each even year, which basically means the same as federal elections. That's the same date as when federal elections are held. Article 9 sets up state guidelines for education, how education is supposed to be administered in the state of Missouri, how educational funds are supposed to be distributed, etc. Article 10 provides for taxation. Article 11 deals with corporations. It gives the legal definition of a corporation and says that all corporations shall be subject to Missouri law, including eminent domain. So if the state needs to take a corporation's property for some public purpose, like take some land in order to build a highway, they can do so. And Article 11 also provides for limited liability of stockholders, basically meaning that you can purchase stock in a company without becoming liable for all of its actions or to pay back all of its debts. Article 12 establishes the process for amending the Missouri Constitution. This process is different from the process for the United States Constitution, as well as much easier, which is also why Missouri has many more constitutional amendments than the federal Constitution. Furthermore, amendments to the U.S. Constitution are included at the end of the Constitution, whereas Missouri generally integrates each new amendment into the relevant article or section of the Missouri Constitution. Amendments to the Missouri Constitution can be proposed in three ways. They can be proposed by the state legislature, by popular initiative, and by constitutional convention. Once an amendment has been proposed, it goes on the ballot for the voters to either accept or reject as they see fit. Since the 1945 Constitution was adopted, 133 amendments have been proposed and 82 have been passed or adopted by the voters. By contrast, the U.S. Constitution currently has had only 27 amendments over more than 200 years, which gives you an idea of just how easy it is to amend the Missouri Constitution versus the U.S. Constitution. Section 3A of Article 12 includes guidelines for establishing a constitutional convention to revise and amend the Constitution. Basically what it says is every 20 years, beginning in 1962, there is an opportunity for the voters at the general election to request a constitutional convention that would evaluate the present Constitution and make recommendations for possible changes. So basically, Missouri voters have an opportunity, they've had an opportunity every 20 years, beginning in 1962, to call for a new constitutional convention. So they had an opportunity in 1962, 1982, 2002, they'll have another opportunity in 2022, and so on, unless they finally revise or replace the current Constitution. And then lastly, Article 13 concerns public employees. It contains rules regarding medical benefits and compensation for public employees.